Okay.
Hi, Manjo. Hi, everybody.
Yeah. Okay. So good evening, everyone. We could begin. I'm just gonna mute all of you. Okay. So everyone has muted himself or herself. Okay, that's good. So tonight we're going to be talking about merit review and administrative tribunals. But before we do that, I'd like to spend a few minutes to answer any question that you might have about the assessments, if you happen to have any. Or perhaps for me to ask, whether or not you've actually made progress in relation to your group assessments. How is everyone doing? Will there still be any questions? Because I think the last time, in the first 2 weeks of the course, a lot of people were asking about what it was that they were meant to actually examine. And I think in the end, I was able to inform all of you that what's really crucial as far as the problem, event, or issue is concerned is for you to be able to identify the facts that would then lead to the problem. So in other words, if you're just talking about a topic, whether it's merit review or it could be Wensbury and reasonableness, it's just a topic. But when you provide facts, the facts usually will tell you that there is a problem or there is an event. So there has to be a series of facts or a set of facts that you need to deal with, because those facts will suggest that there is a problem. So how is everyone so far? We're doing okay with the assessments? We don't have any questions there? None. Okay. So you're happy for us to just talk about tonight's topic on merit review and administrative tribunals? Okay. So this is a very important topic, primarily because we're talking about administrative law, and obviously would be interested in knowing what ways by which we could actually seek a review of administrative decisions, meaning decisions made by the executive, because the executive typically makes decisions that affects us. Those decisions could be in relation to taxes. So in my case, for example, I got audited for the first time by the ATO because I was claiming for some home expenses, because I work from home, and so I asked for some home expenses to be charged against my income so that I would get a tax refund. And somehow I got audited, which I think doesn't usually happen, because my accountant and the auditor, they were surprised why there was an audit. And I said, and it was like, you're in big trouble because you're being audited. And I said, oh no. And the problem with being audited is that when they go back through all your tax returns, it's possible that they may say that, you probably did something wrong and you might be required to do a refund. And the problem, and ultimately, I could sense that there were questions about how the tax officer was trying to interpret part of the tax law concerning home expenses. And so I figured that because I'm teaching administrative law, this would have been a perfect opportunity. If I wasn't happy with the decision of the ATO, this would have been a perfect opportunity for me to apply my knowledge of administrative law to my own problem. So you can sense, therefore, the beauty of knowing about the law. And it could be about Centrelink decisions. It could be about child support decisions as well. For those of you who may have, problems, who've been through a breakup and there are kids involved. And in Australia, for example, if I'm not mistaken, more than 50% of marriages end up in a breakdown, including mine. So in that case, you get caught in the system concerning child support. And you have these functionaries, officers in the executive government, making decisions that affect you. And imagine decisions concerning child support, and they can take a huge chunk of your income and give it to the other partner. And I was in that system last year, and again, the advantage there is that I felt that if I was unhappy with the decision of the child support agency, then again I had the option of undertaking perhaps either an internal merit review through the CSA itself, or progressing it and bringing it to the AAT. And so, because the executive makes decisions all the time about us, it could be about the kind of benefits we get in relation to our children, about childcare, about education, and so on. It is very helpful that we are familiar with administrative review, because what we hope to do, and this is the reason why the Administrative Appeals Tribunal Act of 1975 was actually enacted by the Commonwealth Parliament. It was actually to enable people to have a legal recourse if they wish to question the decisions of the executive. Because prior to that, you could probably seek an internal review from the agency itself that made a decision that affected you, but then your other option would have been to go to court. And that, for you to go to court, it means you need to hire a lawyer, because you don't want to be a self-represented litigant involving a legal matter before the court. The judges are going to be very unhappy with that. And so with the AAT Act of 1975, the Commonwealth Parliament therefore enabled citizens to have the opportunity to have executive or administrative decisions reviewed through administrative tribunals. So that's the beauty of it. And so tonight, we will talk about merit review and administrative tribunals, and we will get a sense of the essential characteristics of merit review and why it might be different from judicial review. We will also be able to examine the jurisdiction of the Administrative Appeals Tribunal, as well, and examine as well the scope of an AAT merits review. So you will notice that our focus, the focus of this lecture, is actually the merits review conducted by the AAT. However, we know that at the state level, there are administrative tribunals as well. So for example, in Queensland, we have the QCAT, which is the Queensland Civil and Administrative Tribunal. And the rules there are obviously different, because in that case, we will realize that the Queensland Civil and Administrative Tribunal, for example, has a fusion of what should have been solely a merits review on the basis of factual issues, but because there's really no separation of powers at the level of the states, these tribunals actually make decisions on the basis also of law, which is not true for the AAT, because the AAT is not a Chapter 3 court, meaning it is not a federal court. And because it is not a federal court, the AAT cannot make a binding and conclusive decision on anything that pertains to the law, because decisions that have a strong bearing on the law are reserved only to federal courts. Okay, so our focus in this lecture is solely on the AAT, which is a Commonwealth or Federal Administrative Review Tribunal. Okay, so we could begin by, so we have 4 tutorial problems for tonight. That's all right, Carrie. I'm glad you're here. So for tonight, we have 4 tutorial problems. Let's begin with the first one. So the Financial Regulatory Agency, or FRA, a federal regulatory agency that regulates the financial advisors industry, ruled that Mr. James Bull did not meet the professional experience requirement to be admitted as a registered financial advisor under the Financial Regulations Act, Commonwealth. Mr. Bull sought to challenge the decision in an application for review to the Administrative Appeals Tribunal. The FRA objected to the jurisdiction of the AAT on the ground that the AAT had no power to rule on a matter that involved a legal interpretation of the Financial Regulations Act, Commonwealth. Is this objection tenable? Any volunteers? So let's give it time. I'd like you to think about that problem. So in general, we know that you're speaking of the, so in fact, the phrase itself, merits review, suggests it is about the merits. And we will later on see that merits usually involves looking at the facts, looking at the policy, the exercise of discretion as well, in relation to whether or not it is an acceptable or a preferable decision. But, so in other words, merits review is not kind of a judicial review or a legal review, because courts, in undertaking judicial review, always examine the legality of an administrative decision. That's the function of judicial review, to examine the legality of an administrative decision. In this problem, it would appear that the financial regulatory agency seems to have made a legal determination as to how the FRA should be interpreted. And therefore, in an application to the AAT seems to be asked to interpret again the Financial Regulations Act, Commonwealth, which again, as I said, seems to raise a legal question. So how does that work? Do you think the AAT has jurisdiction or not?
Manjo, Scott Wellburn here. Well, firstly, you'd have to ascertain if the Act or regulation, that Financial Regulations Act, is actually mentioned, if the AAT is mentioned in that Act.
Very good.
To see.
Well done. Thank you.
Firstly, you'd have to look at that.
Okay, but before you proceed, Scott, why do you need to look at that? Tell me, or tell us.
Because the AAT only has jurisdiction to review administrative decisions when, if an act, regulation, or legislative instrument authorizes the AAT to conduct a review of its decision.
Very good. And otherwise, if not,
then the AAT has no power to do a merits review.
Very good. So that should be clear to everyone. The AAT only has jurisdiction when an enactment, which is the basis for an administrative decision, also provides that an application for review can be made to the AAT. Okay, thank you, Scott. Did you want to continue? Very good, thank you. Yes, so thank you, Kerry. Yes, Scott, did you want to continue?
Oh, I can give it a shot if no one else is looking at it. Go
on.
I would say that, yes, they do have, they can look at it because, and I'm trying to work out how to word this, it's their decision onto the facts as to how the facts apply in that circumstance. So they're making a decision saying that he doesn't meet the professional experience requirements. So it's the tribunal's decision on the merits of Mr. Bull, rather than a strict legislative application.
So in that case, it involves an interpretation of the law. So are we saying that?
Well, I think it's more questions of fact.
Okay. So these are facts, but the facts are actually examined in relation to the law to determine if.
Yeah.
So in that case, there seems to be a need to interpret the law in relation to the facts, or interpret the facts in relation to the law. So that's a question there. In that case, if there seems to be a legal question, does the AAT actually have jurisdiction over that? Or because it seems to involve a legal question, shouldn't the proper recourse be for a judicial review to be undertaken? Scott could continue, or if anyone else would wish to pick up from where Scott left off.
I'll pick up if you like.
That would be Kerry, yes.
Yeah, Kerry. The problem is that he has not met the professional experience required
Mm-hmm.
to be a registered financial advisor, which is under a Regulations Act, a Commonwealth Regulations Act.
Mm.
Now, unless he meets, that's a strict regulation that if he doesn't meet it, he needs to meet that. There's no way around that. The judicial process would be looking at whether a process has been inaccurately enacted, whether the FRA did something wrong in assessing his application, or whether they had not followed the correct procedure in his application.
Mm-hmm.
But in this case, they've followed the procedure and they've based their knockback based on the professional experience requirement of the Act. We don't know that. We don't know that rule.
Mm-hmm.
We're not given that. But I would say to Mr. Bull that he should look at what the requirements are and whether he put all his qualifications down. And if he did, then he didn't meet it. If he didn't, then he would have to reapply.
Mm-hmm.
And that would be more of the way that I would look at that.
But we're still, thank you, Kerry, but we're still left with that question. Does the AAT have jurisdiction over this specific application? Because that's the point, the objection being raised by the FRA. It seems to involve a legal question. It involves the interpretation of the Act. Because it is a legal question, the AAT can't have jurisdiction. It has to be the courts. That's what the FRA is saying. How do you respond to that?
Would it be?
I would say yes, because
which one is yes?
Kerry.
Yeah, I mean, yes. Therefore, what? Yes, that.
I would say that the Administrative Appeals Tribunal would not have power under this. It would have to go to a judicial appeal if he's going to appeal above an FRA. If the FRA is the Commonwealth body that regulates the financial advisor industry, then they're following the process, and he's actually appealing under a legal appeal, and therefore that would have to go to a judicial appeal.
Thank you, Kerry.
Manjo, if I could
yes.
give another run. Isn't judicial review concerned more with if it's shown that the executive or the act made by the executive contravenes the law? So the actual, it's not unlawful, or it doesn't appear to be unlawful, the requirements in the Act, in that Financial Regulations Act. They can put requirements in there that don't appear to be unlawful. So wouldn't the courts then, because that's a matter of policy, and the decisions are made around this regulatory agency, a policy set by the executive, that would be more under the scope of a merits review rather than the courts interpreting it under a judicial review, because it doesn't appear that the legislation is unlawful.
Okay, two things. In the first place, under the facts, we're not dealing here with policy issues. This is a legal question that's being raised. So for the moment, let's set aside the issue about policy, because if it were to involve policy, then obviously it is not apt for judicial review. The question, as we said, is that this seems to involve a legal question. As you correctly said, judicial review would examine the lawfulness of an administrative decision, in particular to determine whether or not the decision is consistent with the law. But even that formulation is quite broad. What exactly do we mean when we say that an administrative decision is legal or lawful according to the law? And if we accept that, does it mean, therefore, that the Administrative Appeals Tribunal does not have jurisdiction, therefore, to examine an administrative decision as to whether or not it is consistent with the law? So in other words, the moment that a party, for example, in the administrative agency asserts that the AAT needs to interpret the law, meaning it involves a question of whether or not the decision is consistent with the law, then necessarily the AAT does not have jurisdiction. So by raising that objection, are we saying that the AAT automatically loses its jurisdiction? Okay, hang on. So again, let me clarify the way I deal with the tutorials, okay? So what I'm actually doing is ask questions. Sometimes they can get confusing because I ask too many questions and I don't really provide the answers yet. But I just like this approach because I want you to think instead of me telling you the answers straight away. And I think that, you know, when you're confronted with these questions and when you begin to really think about them, then there's a higher likelihood that they stay with you, rather than if I were going to, again, give you another lecture by telling you these are the facts and this is the answer. So it can be uncomfortable to some, but I'm hoping that, you know, you will tolerate and begin to appreciate that there is benefit to this approach, which is actually called the Socratic method. So I hope that's all right with you. So the correct answer is that the objection is actually untenable. Okay, so the objection cannot be upheld for the simple reason that when there is an application for review with the AAT concerning an administrative decision, necessarily, in the first place, when the administrative decision okay, I'll have to turn off the mics for the others. Hang on, because I'm picking up some sounds. Give me a second. Okay, I can't seem to mute everyone else. Okay, can I just, there is a background sound there somewhere. Can I ask everyone else to just mute his or her microphone? Okay, so going back to that point, where was I? Okay, so when the original decision maker makes a decision, that original decision maker obviously made a decision in relation to the law. So the original decision maker itself, meaning the FRA, made a decision as to the fitness of Mr. Bull in regard to the law. So to that extent, the FRA was making an interpretation of what the law required. Okay, that can't be helped because that is the job of an administrative decision maker. The original administrative decision maker must obviously act according to the law. Now, it's possible that the administrative decision maker can act according to policy, that's fine. According to discretion, that's also fine. But in relation to the professional experience requirement, because it is according to the law or a requirement of the Financial Regulations Act, then it is necessary for the FRA to make a decision or an interpretation of the qualifications of Mr. Bull according to how it interprets the law passed by the Commonwealth Parliament. Now, so in the application, therefore, to the AAT again is confronted with a question of whether or not, when the FRA made the decision, in relation to the professional experience of Mr. Bull, whether that interpretation was actually according to the law. Scott, did you raise your hand? Yes.
Oh, yeah, just one thing. Could you simplify it by saying that under the AAT Act,
Yes.
they have the AAT has the authority to make a decision in this matter, because a decision under, I think it's Section 3, a decision includes issuing, suspending, revoking, or refusing to issue a license, authority, or other instrument, which is what they're doing here. They're refusing to issue authority for him to be admitted as a registered financial
advisor. That's right. So that is one of the elements that has to be satisfied before the AAT has jurisdiction. But that's only one of the elements. The other element really is whether or not this is a proper application or a proper question over which the AAT has jurisdiction. I mean, apart from the nature of the decision, we talk about the standing as well. So we're not talking about that. Really, we go back to the question of whether or not, given the fact that there seems to involve a legal question, whether or not the AAT does have jurisdiction. And the answer is yes. Okay, because as I said, necessarily when the AAT reviews an administrative decision, it has to take into account the way that the original decision maker made a decision, and also a determination of whether or not it was according to the law. Now, there are two things we need to consider here. Any decision that the AAT makes in relation to how it perceives the original decision maker made a decision according to the law, that is not final and conclusive, because only the federal courts or the Chapter 3 courts have the power to make a final and conclusive decision as to what the law is all about and whether or not a certain act is actually lawful or not. Now, the second thing we need to consider is that if by raising the objection that the application does involve an interpretation, or at least a preliminary interpretation of the law, if by raising that objection alone, the AAT then is divested of its jurisdiction, then it will mean that a lot of marriage review applications before the AAT will necessarily have to be dismissed by the AAT on the ground that it lacks jurisdiction. And in that case, all the questions will then go to the courts. And so in the case of Collector of Customs versus Brian Lawler Automotive, this was in fact the decision of the Federal Court of Australia. That the mere fact alone that in an application for review to the AAT, there seems to be a question that is raised that seems to involve a legal question, that alone will not divest the AAT of its jurisdiction. It should be noted, however, that any decision of the AAT that seems to involve a determination of what the law may be saying on a particular subject is not final and conclusive, because only the courts have the power to make a final and conclusive decision on what the law is. Okay, so in answer to this question, the objection therefore is untenable. The AAT does have jurisdiction, although the interpretation of the AAT, as I said, is on that legal question, or that limited legal question, is not final, and neither is it conclusive. Okay. Question 2. In a case before it, the AAT considered evidence and matters that were not before the decision maker. Party X argues that the AAT went beyond its powers. Is this correct? So in other words, so a decision had been made by the original decision maker. In an application for review with the AAT went beyond the evidence and matters that were actually covered or reviewed by the original decision maker. Is that in error? Is it wrong for the AAT to examine evidence that was not even before the original decision maker? Or is the AAT limited, for example, to evidence, what was that? To evidence, to reasons, and other matters that were raised before the original decision maker, so that if evidence, matters, or issues were not raised before the original decision maker, it is too late for the applicant then to raise it before the AAT. So that's what Party X is saying, that the AAT went beyond its powers. Is this correct?
Have a shot, Manjo?
Yes, who's that?
Sorry, this is Nick.
Nick, thank you, Nick. Yes.
Thanks. So I'd say it's incorrect. So I guess the issue in this is whether the AAT can consider evidence of matters that weren't before the original decision maker. I guess the rule in this would be Section 33 of the AAT Act, where the tribunal can inform itself on, I don't have the precise one, but such matters as it thinks appropriate. So I'd say apply to this. The AAT has very broad-ranging powers. It can take in new material and new evidence and new interpretations, as we previously said, of policy and legislation, of legislation, such that it can reach its correct or preferable decision. So I'd say it's within its powers, and the argument is incorrect.
Very good. So thank you, Nicholas. So what Nicholas clearly was correctly said is that when you have a merits review before the AAT, the AAT essentially does a merits review de novo. It is as if it is starting from the beginning. And so it is therefore within the power of the AAT to satisfy itself as to the matter before it. And it therefore is permitted to consider evidence and matters and issues that were never traversed or taken up or raised before the original decision maker. Okay, so that's a de novo. So there's a de novo hearing proceeding before the AAT. Now, the other question related to this will be, would it be permissible, for example, for the AAT to try to seek new evidence? So it's one thing for the applicant to bring to the attention of the AAT certain evidence that had not been taken up or had not been examined by the original decision maker. But would it be permissible for the AAT to, on its own, try to require the presentation of new evidence, even if this had not been suggested either by the original decision maker or by the applicant or by the by the citizen who made an application before the AAT? So as I said, it's one thing for the applicant to bring to the attention of the AAT certain facts, evidence, issues, matters that had not been presented before the original decision maker. My question is, can the AAT on its own suggest, request, require the parties before it to adduce, present evidence, or raise issues or reasons that had not been suggested or raised by the applicants themselves? That's the other question.
May I answer? I think that the tribunal can bring a new evidence and inquire about it, because the tribunals got inquisitorial manner, and they can actually, because they want to come to the fair and just conclusion of the matter, so they can actually ask for extra evidence, even if the parties did not bring to the proceedings.
Fantastic. Thank you, Grace. So that is a correct answer. Thank you. Thank you. Any questions on this question before we go to question 3? Fantastic. None? Okay, let's go to question 3. So students protested against the visit of the Chinese defense minister to the Australian Parliament in February. When the student protest went out of control, student Josh MacArthur suffered injuries after he was shoved to the ground and kicked by a member of the Australian Federal Police. He filed a complaint to the Commissioner of Police against the police officer who caused his injuries. After an investigation, the Commissioner of Police made a finding that the police officer involved in the incident was not at fault and decided against taking any disciplinary action against the police officer. Josh intends to have the decision of the Commissioner of Police reviewed and has come to you, a solicitor, for advice. He wants to know if he can file an application for review to the Administrative Appeals Tribunal. What would you tell him? Volunteer.
Can I have another crack at this one, Manjo? Sorry.
Sorry, what was it?
This is Nick.
Yes.
And sorry. This piqued my interest, so I was curious on your thoughts. I really felt like this was a matter of standing, and whether he would have, Josh would have standing in the decision of the Commissioner of Police in a disciplinary decision of one of his officers. I would feel that may not meet the remoteness test that he would need, but I'm very, very interested.
Okay. Nick, I'm very curious. Are you saying that Josh, who actually suffered injuries, does not have standing?
So I'd say
that his rights have been violated. I mean, if you've been shoved and kicked to the ground, it should be quite easy to assert that your rights have been violated. The right against what? Against being manhandled, right against not being injured, right to be dealt with in a proper way by the police. So I think that question of whether or not he is standing, I wonder if that's probably a given.
Yeah, I guess I just meant, I mean, I can't see that the outcome of a disciplinary hearing that the police would affect Josh in any way other than give him some personal satisfaction that an officer had been.
Is that what you meant? I see.
Yeah, that's more what I meant.
Okay, good point. Thank you. I saw Karen raising her hand, I think. Yes, Karen.
Yeah, I was wondering if this was one of those decisions that would be excluded on the grounds it's a decision of a law enforcement nature and therefore is excluded from merits review.
Interesting. Would that decision involve law enforcement?
It's the police acting in the course of their duties.
But I mean, is that the job of the police? Is the job of the police to push people to the ground and kick them?
Well, I suppose it depends what the students were doing. If the students were attempting to rush at the Chinese minister's motorcade and throw themselves in front of the car and that sort of thing,
okay,
it's up to the police to try and stop that happening.
Could it be possible to make a distinction between police action in the sense that it is for the police to determine whether or not a complaint should be filed against certain individuals? And in that case, according to the Aat Act, then that is an excluded decision and cannot be the subject of review, for example, by the Aat. But this is not a question about a police investigation of a potential crime. This is a complaint by a citizen who felt that his rights had been violated by the police. I'm not sure if... I saw somebody raising her hand earlier. Who was that?
That was me, Manjo.
Carrie, Manjo.
Manjo.
Yes.
I'll get it eventually, I'm sorry.
Okay.
Bring to mind is the Police Powers and Responsibilities Act and the Police Powers and Responsibilities legislation, both of which would not certainly cover the police in doing such an action. And it would be I would feel that he would be able to file an application for review to see whether or not they had violated their process of assessing police officers' duty under those two acts, especially with the fact that he's being manhandled, shoved, kicked to the ground by a member of the Federal Police, and that they've made a finding that the police officer involved in the incident was not at fault. That goes against the Police Powers and Responsibilities Act, in certain sections.
Okay.
So have to look at the processes involved.
Thank you, Kerry. Any other comments before I say anything? Maria, I'll go to Maria, and then, was it Scott after that? Yes, Maria. Yeah. I'll go to Maria, then I'll go to Scott.
The tribunal may not have jurisdiction over this because Josh wanted to file a complaint against an Australian Federal Police. So it may be outside its jurisdiction.
Okay, so Josh filed a complaint with the Australian Federal Police. The Australian Federal Police, which is an executive agency, made a decision, which we can say is an executive decision or an administrative decision. The question now is, that administrative decision of the Commissioner of Police, can that be subject to review by the AAT? That's really the question. Scott, did you want to say something?
Yeah, I think probably a more appropriate channel for him to file a complaint or an application for review would be to the Crime and Misconduct Commission.
Okay.
Would that be a more appropriate avenue for him to source justice? If he thought what the police officer did to him was unlawful, he could complain to the Crime and Misconduct Commission and they could investigate it. Alternatively, if he thought that the police's investigation of their own members was insufficient, equally he could make a complaint to the Crime and Misconduct Commission as well, and they may investigate it and come to a decision. Possibly,
but it doesn't. It still leaves us with a question, and the question really is: could an application for review be made to the AAT? We still haven't answered that question. I agree. There are other ways by which this decision of the Commissioner of Police can be reviewed. And you correctly pointed out, perhaps that particular agency that you mentioned could be one of those agencies to which you could ask for a review. But that does not still answer the question that we have. In this
I don't, it doesn't say in there, but I don't think the actions of the police officer, like what legislation are we looking under that would give the AAT the authority to conduct a merits review? Under the AAT Act, it can only conduct merits or it can only conduct review of acts that specifically mention that it can conduct a review into it.
Very good. You're getting there.
Looking at.
Okay, so Scott, you're getting there. So what exactly are we saying here? What are the there are at least two other jurisdictional requirements that need to be satisfied, that need to be shown and then satisfied for the AAT to have jurisdiction over this particular application. So you've already cited that. What are those? What are those two jurisdictional requirements for the AAT to have jurisdiction over this application? You mentioned it.
One that they're named in the legislation that they...
Yes, that's good. So that's one. The legislation itself must provide that this is a reviewable decision. A decision that can be reviewed by the AATs. In other words, we don't really know the facts. So the answer will be, it depends on the legislation. Does the legislation provide that a decision is subject to review by the AAT? That's one. What is the second jurisdictional requirement in relation to enactments? What is it? So one, the enactment must provide that it could be reviewed by the AAT. What's the other one? Related to enactments, which is always crucial when it comes to AAT reviews.
that the decision was made under the enactment.
Very good. Fantastic. Okay, well done. So there are two other jurisdictional requirements that must be satisfied for us to say that an application for review could be entertained by the AET. The first is that the administrative decision must have been made under an enactment. So in other words, if this particular decision was not actually based on an enactment, but something else, it could just have been some usual disciplinary process. So it's not based on an enactment. So I mean, in other words, decisions are made by administrative agencies, not always based on an enactment. So oftentimes disciplinary actions could be made not on the basis of an enactment. So that's the basic question we need to ask. Was this administrative decision made on the basis of an enactment? Which could have said that the Commissioner of Police, in investigating a complaint against the police, must observe these guidelines under the law. Okay, so that's the first question, as correctly pointed out by Nicholas. And the second question is, the second jurisdictional requirement, as correctly pointed out earlier, was that the enactment itself, which had been the basis for the decision, would have provided that an administrative review could be made by the AAT. Very good. Questions? None? Okay. Final question. Kim Upshot operates a car rental business and has been doing most of the business accounting tasks on her own. An audit by the Australian Taxation Office revealed that Kim had misinterpreted key provisions of the Australian tax laws and, as a result, was deficient in the payment of taxes in the amount of $4,965. She asked the ATO to review her tax liabilities. The ATO affirmed its decision and reiterated the reasons for her tax liabilities. She was advised by the ATO, however, that the relevant laws allowed her to have the ATO decision reviewed by the Administrative Appeals Tribunal. Kim then sought legal advice to determine the next step she should take. A tax lawyer was of the view that a proper interpretation of the relevant tax laws and certain factual matters not brought to the attention before the ATO would show that Kim only owed $2,464. At the tribunal, Kim included in the statement of reasons for her application that the ATO interpretation was wrong and that it had failed to consider certain factual matters that would have caused a reduction of her tax liabilities to $2,464. The ATO argued that it was not open to Kim to raise these new matters as they had not been brought before the ATO. It argued further that the tribunal's power of review was limited to the matters and reasons cited in the ATO decision. Who is correct and why? Okay, got an answer there from Maria. Kim is correct. Maria, would you like to pick up the microphone?
Okay. Well, the ATO is wrong in saying that Kim cannot raise new matters. In fact, under the AAT, they are the citizen is allowed to raise new issues and new evidence. I can't find where it says in the book. Sorry, Manjo, forgot. Kim can raise new evidence to support her argument, which is allowed in the AAT review. Okay. And she could also raise the fact that the ATO may have erred in their review of her case.
So that's correct. Okay, so in this case, Kim actually is correct. In fact, Section 29 actually requires applicants who make an application for administrative review that they should be providing the reasons for their application And there is a requirement that the reasons are those that have been raised before the original decision maker. So the applicant can raise any decision. And in that case, it will in fact then be up to the ATO to accept those reasons or not. The other question though is, would the ATO be permitted to justify its decision on the basis of a reason that was neither raised before the original decision maker and was not even raised by any of the parties? So let me repeat. So we know already that the applicant is permitted to raise in her application or his application reasons which were not raised before the original decision maker. My question now is the ATO permitted to cite in its decision reasons that were never raised before the original decision maker and were not even raised by any of the parties in the proceedings before the AAT? What do you think?
Yeah, I think they can still look at all the information. It's a de novo hearing, so the AAT is not restricted to the submissions put to them. It's not restricted to the reasons originally advanced for the decision. They're not constrained by the grounds for review, the grounds relied upon by the decision maker.
Mm. Thank you, Scott. I just saw Karen raising her hand. Karen.
Is this the bit that you've mentioned in the notes where it says the tribunal's ability to consider evidence not before the original decision maker may be precluded by the nature of the decision?
Mm. Mm.
So, because they're saying, well, yeah, we may well have made a different decision if we'd have had all these facts, but these are the facts we operated on at the time we made our decision.
Mm. So the general rule really is that at the AAT is not precluded from entertaining any reason or even citing a reason for its decision that was never brought before the original decision maker, nor were raised by the parties in the proceedings before the AAT. So that is really the general rule. Now, there may be instances when the AAT may be precluded from citing reasons that were not raised before the original decision maker, or that that were not raised by the parties in the proceedings before it. But that would mainly be very limited. And I think the few instances when that can happen would be that when its reasons would actually, for example, violate the rules of natural justice. Because the requirement really is that in any proceeding, especially before the AAT, the parties must be given an opportunity to be heard. And what this actually means is that if they are given the opportunity to be heard, then they must be given an opportunity to know how a decision can be made, including the reasons for the decision that can affect them. So in other words, if a decision is made on the basis of reasons to which the parties never had an opportunity to be aware of, then it can be claimed that there is a breach of natural justice. Because in that case, it's like, if you're being blindsided. All of a sudden, the AAT has come up with a reason that is very foreign to the proceedings. No one knew about it. And then it makes a decision on the basis of that reason. It can happen, but it very seldom happens. So as a general rule, the rule is the AAT is obviously permitted to cite reasons for its decision. Reasons, even those that were never raised before the original decision maker, or rather even those raised by the parties. And the assumption there is that these types of reasons that would have been cited by the AAT in their decision would have been reasons that would have been within the normal contemplation and possibly could have been entertained by the applicants if they wanted to. So in other words, you know, they would actually, if they wanted to, they could have presented it. But a decision that, you know, that is just totally foreign, that just blindsides everyone, we might say that in that case, that can potentially be a breach of natural justice, because in that case, there should have been an opportunity, for example, for the parties to be heard before any such a decision would have been cited by the AAT in its decision. Okay. Questions? Yes, Maria. Yes, Maria.
Okay, just thinking about this, Manjo, in this instance, would the AAT hold the ATO to a higher standard? Because they're meant to be ATO, that's what they do. Whereas Kim is a small business owner, she's not an accountant, so she could have made a mistake when doing her business tax. But whereas if ATO presents a new evidence, shouldn't they have seen that before? Shouldn't have they discovered that? Would the AAT hold them to a higher standard?
I don't think so. I haven't seen in the legislation, nor have I seen in any of the cases decided by the courts, that there is a presumption against the administrative agency. There isn't any such presumption. In fact, typically, when it comes to administrative law, there is a presumption that the actions of the executive officers are according to law. If there is any presumption, there is a presumption of regularity of official functions. So there is a presumption in law, in common law. There is a presumption that when executive officers or agencies perform their functions, they are performing it according to law. There is, in fact, that presumption. So I would seriously doubt that there would be a presumption that is against that common law presumption, which actually then puts a higher burden on executive agencies. I don't think there would be any.
All right.
Yeah. Okay. Any questions before we end tonight's tutorial?
Manjo?
Yes, Megan. Yes.
I'm just wondering, in that sort of case, would they usually like remit it for reconsideration, or you know, what's the usual outcome of something like that? Is there more so a usual outcome than other?
So this is a theoretical problem that I created. So okay, so this is based on an actual case. I created this problem. Now the question is, in a typical case, would it mean remitting the case to the original decision maker? It actually all depends on the AAT. It depends on the factual circumstances. Because remember, what we need to remember is that if there's an application before the AAT, that is on the basis of the individual factual circumstances of the applicant. And in fact, the decisions of the AAT are not meant to be binding. There is no precedent. There is no rule of precedence as far as AAT decisions are concerned. So the AAT is supposed to make a decision on the basis of the facts before it. Now, whether or not it will remit it to the original decision maker really depends. For example, it could depend on the fact that there is a need for further evidence to be presented. And for that evidence, therefore, to be presented, it will require an enormous amount of time. In that case, the AAT will likely say, why don't we remit it to the original decision maker, so the original decision maker can then look for the evidence, one. Or two, it might be that there could be a remittance of the application back to the original decision maker if the factual circumstances require a certain level of technical expertise that might be beyond the expertise of the AAT. And then they would say that in this particular case, it would be better for the original decision maker to examine this particular aspects of the factual scenario. Now, otherwise, the AAT can make a decision, but it is within the power of the AAT to remit an application back to the original decision maker. Does that answer the question?
Yes, it does. And I find it odd that the decisions aren't binding, but then in section 43(6) it says if the AAT varies or substitutes a decision, the decision is considered a decision of the original decision maker.
That's right. Yes, but it doesn't bind the rest of the AAT. So in other words, assuming that there was a decision on exactly the same provision of law involving kind of the same facts, and then so involving obviously a different party, and then there is a similar case involving kind of the same facts, different party, but involving the same provision of the law, it cannot be said that the next AAT tribunal or panel will have to make a decision on the basis of what the previous AAT panel did. No, because there is no binding effect in that sense. Because every AAT decision is particular, unique, and peculiar according to the facts of the case.
So, Manjo,
yes.
When you say it's not binding, you mean it's not setting precedent as such?
That's right. Yes, that's right. So because there is no concept of precedent or stare decisis in administrative tribunals, unlike in courts, where we have the principle of stare decisis, where courts are meant to follow judicial precedents. Okay, so thank you everyone for tonight's engagement. Thank you for really being very active in tonight's session. And if you have any other questions about the assessment, feel free to send me an email. Otherwise, I bid you a very good night and have a nice dinner. See you everyone. Good night. Bye.